For once, we agree with Kash Patel. Hi again, everybody. It's 5 o'clock now in New York, meaning a strict new deadline just passed moments ago for the Trump Justice Department, whose indictments, as you just heard, in their view, speak powerfully in court until they don't. Because this afternoon, in a rare and remarkable ruling, a federal judge in Virginia ordered the government, the Trump Justice Department, to hand over the grand jury materials, including audio, in the criminal case against former director of the FBI, Jim Comey. Now, why did the judge do that? Well, he explains, because there are evidently, quote, genuine issues of misconduct, end quote, issues apparently so serious that Comey could see his charges dismissed altogether. In his ruling, for which the DOJ sought an emergency stay, U.S. Magistrate Judge William Fitzpatrick noted how rare it is to allow a defendant access to grand jury materials. However, he says, quote, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding, end quote. Of course, the official presiding over this, quote, disturbing pattern is the aforementioned interim U.S. Attorney Lindsay Halligan, a Trump-appointed official who had never prosecuted a case before prior to this one, when she overruled the objections of career prosecutors in that office. More from today's opinion from the judge, quote, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity generally associated with grand jury proceedings, and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. All of this lines up perfectly with what is the most comprehensive reporting to date of the troubling atmosphere inside Donald Trump's Department of Justice right now. The New York Times interviewed more than 60 attorneys from the agency, either recently resigned or recently fired. The picture they paint is genuinely horrifying for anyone who appreciates the rule of law or appreciated. A former lawyer in the Civil Rights Division told the New York Times this, quote, I wouldn't even call it the Justice Department anymore. It has become Donald Trump's personal law firm. I think Americans should be enraged. We all deserve better than this. I keep telling my colleagues still working in the division that I'm holding the line with them from the outside, but I feel guilty that I'm not holding the line with them from the inside. That is where we begin the hour with some of our favorite experts and friends. Former Assistant Special Agent in charge at the FBI and National Security and Intelligence Analyst, Michael Feinberg, is back with us. He's also a fellow at Lawfare. Also joining us, former top official at the Department of Justice and legal analyst, Andrew Weissman's here. Let me start with the judge's extraordinary wording. And this is something I delved into, I believe, with both of you last week on the questions around what was presented to the grand jury in the Comey case to reach an indictment after Eric Siebert, who was MAGA adjacent, MAGA in good standing with Pam Bondi and Todd Blanche, but resigned over this case, saying there wasn't enough evidence to take it to a grand jury and reach an indictment. Lindsay Halligan comes in. We played Kash Patel, toasting her, feeding her, and pointing to the results. The result of Lindsay Halligan so far from this judge is failing marks. Andrew Weissman, explain.
Well, some of this is the result of, in the grand jury, you would think that Lindsay Halligan, who has no criminal experience until she took on this role, you would think that somebody would have gone into the grand jury with her. Instead, we know from the judge's opinion that she went in alone. And so part of what the judge called out here was at least two things that she said that are partially redacted, meaning we don't see all of it, that he says are highly problematic and thus justify giving the grand jury transcript to the defense so they can make motions about it. But that's sort of like Keystone Cops stuff. The idea that we know that nobody in the Eastern District of Virginia no career person was willing to do this. But you think somebody at Main Justice would have said, we're going to send somebody with some experience in there. Let's just for a moment think that we were dealing with a defendant who was guilty of something really serious, like a terrorism offense. Is this what you want from your FBI and your Justice Department? Is the kind of violations that the judge calls out here and says that there is probable cause to find. And you see this sort of what I think is sort of reminiscent of what we saw with the Charlie Kirk investigation, where the FBI and the American public and Charlie Kirk's family got lucky. It wasn't because the FBI and the Justice Department were doing a good job. And you're seeing that play out here, which is just rookie mistakes. And to be clear, rookie mistakes that this judge says have all of the look and feel of violating the Constitution and the attorney-client privilege of James Comey. So this is more to come, but incredibly serious allegations by the judge here.
Is it enough, Andrew, to get the case dismissed?
It may be enough to dismiss the indictment. There are other grounds as well, such as the appointment of Lindsay Halligan, but it also signals to me that there are going to be at least very colorful, if not winning, arguments to suppress evidence. The judge calls out a Fourth Amendment violation here. It remains to be seen how big a taint that is and whether the government has some arguments on the other side. But if you just get evidence suppressed, and there isn't a lot of it here, there's very, very little evidence. That's why you have all these career people and even Mr. Seibert saying we don't want to bring this case. But if you actually violated the Fourth Amendment, then the judge is free to say we are suppressing that evidence, and you need to have evidence in order to actually go to a trial.
Michael, let me read you the judge's own words on what Andrew's describing. After reviewing the grand jury materials himself, the judge wrote that Halligan appeared to make, quote, two fundamental misstatements of the law that could compromise the integrity of the grand jury process. As Andrew said, the specific statements are redacted in the opinion, but the judge noted that they gave grand jurors the wrong impression about Comey's legal rights. When we talked, the three of us talked last week, and reporter Glenn Fresh was here as well, we talked about why that wasn't out yet. Where was the missing transcript? I mean, we now know that the judge knew what was in there, and it wasn't a good story for the Department of Justice.
Yeah, I don't think the Department of Justice or the FBI, in terms of the investigation leading up to the indictment, neither of those organizations are exactly covering themselves in glory here. For those who haven't read the opinion, the order that came out today, and for those who may not be as familiar with the prosecutorial and the indictment process as Andrew and I, this was less a restrained memorandum than it was an utter evisceration of how the FBI handled evidence and then how that evidence was presented to the grand jury. And, at the end, there is a numbered section, I think he gets up to about a dozen, just mistakes that were made by the government in this process. And this is unfortunately, as career officials are driven out of DOJ and as they're driven out of the FBI, and you get lackeys coming in willing to replace them, we're going to see more of this.
Yeah, I mean, Michael, that is the subject of this broader piece of reporting today that we have in the New York Times. Let me read you some of that. This is about Dina Robinson, a former lawyer in the Civil Rights Division, says our job wasn't to engage in fact-finding investigations. Our job was to find the facts that would fit the narrative that the administration already had. That is not how the division worked. My colleague told me that the experience demoralized and eventually broke them. It ended up being the reason they left the Justice Department. You, I think, left with a similar impression and wrote this incredible canary in the coal mine account of what was happening at the FBI about polygraphs and Kash Patel. But I wonder what it's like to see the other pieces of the puzzle fall into place from literally every corner of the FBI and DOJ.
So I think that the article, which was incredibly powerful to read, actually understates the problem. Wow. That article was drawn almost entirely from individuals who sit at the main justice headquarters, the RFK building. I think there were 3 quotes from federal prosecutors and U.S. attorneys' offices in the entire article. But it's important to remember that the Justice Department is a huge organization. It has dozens upon dozens, I think 90-something U.S. attorneys' offices whose personnel were not interviewed by the New York Times. And I know from talking to acquaintances and friends and former colleagues in those offices that they feel the same. And in addition to the U.S. attorneys' offices, you have all the component agencies, not just the FBI, but the DEA, the ATF, the U.S. Marshals, the Bureau of Prisons. This article could have been written about any of those organizations. This is much more dire than people realize, not just because of the erosion of rule of law, but also because as these people flee the organizations, there's a real loss of state capacity, a real loss of people who know what they're doing. And that's why we find ourselves in situations like the one we're discussing about Lindsay Halligan.
The judges. It was almost poetic in a cruel way. After years of chaos, it wasn't a revolution, an election, or a protest that finally cornered Trump. It was the one thing he'd always treated as irrelevant: the law. For a man who lived his entire life bending rules, buying silence, and suing his way out of trouble, being told no was more than defeat. It was exposure. He thought the courts would protect him. After all, he'd stacked them himself. But the thing about power is that it believes its own myth until reality breaks through. One by one, judges, even the ones he'd handpicked, started ruling against him. They quoted the Constitution instead of cable news. They treated him not like a king, but like a defendant. And suddenly, the showman ran out of stage. That's when the rage began. He attacked them all, called them corrupt, biased, enemies of the people. But the truth is, he wasn't afraid of injustice. He was afraid of accountability. Because accountability doesn't bend to charm or threat. It's cold, procedural, boring, and unstoppable. It's the one thing that can't be bullied. Every courtroom became a mirror he couldn't break. Every ruling stripped away the myth he'd sold, that power makes you untouchable. And as the verdicts rolled in, civil, criminal, financial, America got to see something it hadn't seen in years. A system remembering what it was built for. Maybe that's why it mattered. Not because the judges were heroes. They weren't. They were just doing their jobs. But that's exactly what made it powerful. In an age of noise and spectacle, professionalism became rebellion. Integrity became resistance. And in those quiet moments, as gavels fell and lawyers argued, democracy found its pulse again. Trump always believed he could rewrite reality if he shouted loud enough. But law doesn't listen to volume. It listens to evidence. And when the shouting stopped, what was left were documents, signatures, and truths that didn't care about politics. That's how power ends, not in flames, but in paperwork. And maybe that's the final irony. The man who built his empire on television was finally undone by transcripts.